Yes.
I recommend you content for listed.
Contempt case policy. It'll come. It's a new case or what?
It is listed on 21 to 2024 and honorable for the direction to list of matter after 2 weeks. But in this next week, of the any date,
That's not even late.
particular. I think it's for 16, 17, and 16.
Yes.
After 3 weeks,
Why?
my students
Who's the senior? Huh?
in item number 17.
You're for whom?
Yes.
You're for, the Borbahin is for whom? Which respondent?
Petitioner for the item number 17. I have taken the concept of third to fifth price. Item number 16 and 18 at the article.
Just give me item 15, 17, 18. I think this matter pertains to period. Huh? Fishery. Pertaining to which period? When was it settled?
2022.
2022? Or, huh? 22. What about the respondents? Have you taken the consent of the respondents? Any objection? No stay order. Okay, right. On the prayer for adjournment made on behalf of Ms. D. Borbain, Learned Counsel for the petition in WPC 2744/2020, which is not objected to by the counsel for the other parties. This is the matter. This is the matter of 16/5.
May it please the lordship. I pray for Uttara matter. It can be removed.
May please the lordship. Lordship, document item number 19 and 20 of this series. Yes. Lordship, we have finished our affidavit. We are going to send it for vetting today. Lordship, can it be after 2 weeks? We have taken concern of the other side as well. Yeah, for whom? Lordship, respondent. PW. Who's for the petitioner? We have already taken the consent. But there is a clause on the dispute redressal system. That I'm not aware of that. You're not aware of that? You have not read the writ petition? I have not. When will the defect liability period be over? Affidavit has already been filed by one respondent. By response, huh? There were other writ petitions of the similar case. There are only two writ petitions here, Mister. One is 4260 and one is 4258. 4258 has been filed. We are filing for 4260. The same thing will be filed. Why can't it take care of the other thing? When will you file? When will you file? 2 weeks, sir. Why 2 weeks? We are sending it for vetting still. Mister? M here, Lord. M? We are appearing for Mr. B. Gogoi, SCPWD. Submit that. The affidavit to be filed in relation to WPC 4260/2020 has been set for vetting. Accordingly, placed for 2 weeks time to file the check. As allowed, this is the matter after 2 weeks. Good stuff. It is seen that affidavit of possession has been filed in WPC 4258/2020. Yes. 14, yes. I know. No, you see, this matter, I think we'll have to release it from Pathar. It cannot remain in Pathar because it is now, it's the Supreme Court is seized of the matter. Just give me this case. I don't put it. Mr. DK Bora appearing for the petitioners and Mr. S.S. Roy appearing for the respondents number 2 to 6. Submit that. The present matter no, the summits that the Supreme Court has stayed the order dated 7/3/2020 and has stayed the order uh, has stayed the order dated 27/2/2024. Correct? 27/2. Or no, or any further proceeding of this. 27/2/2020 has stayed the proceedings of this case in SLP bracket civil number 9653/2024. By the order dated 7/3/2020. So accordingly, the matter is adjourned. The case is also released for party due to the pendency of the case before the Honorable Supreme.
May I please your lordship, item number 29.
29.
Yes, lordship. The consent, please. We have taken the consent of the respondent as well.
Huh?
We have taken the consent of the respondent.
29 and 30 are same.
Yeah, lord.
I mean, this is-
I'm
but
on behalf of item number 29
you're for whom?
for the petitioner.
RM Das.
Yes, lord.
Who's for the other side? Correct. On the prayer for adjournment made on behalf of Mr. RM Das, Learned Counsel for the petitioner in the contempt case. This is the matter after 3 weeks.
Authorize your lordship. Please, your lordship. I take mention item number 22.
22, yes.
Which is lordship with the consent of petitioner.
Why? You're for the
If I'm preparing on behalf of the
no. It has been adjourned all the time on his behalf. No further adjournment. If he comes, well and good. If he doesn't come, I'm going to dispose of the case. Please, I'd like to mention one item for mentioning. For mentioning? You're already making a mention. For listing of a matter. For listing. This case was last listed on 22/11/1/2024 and the respondent took 2 weeks time to file their affidavit. Here, Your Lordship. Is it a writ petition or a contempt or what is it? This is the writ petition. Give it this. Can I see on 24th? There is the address. What is the agency? We are to receive 3 crores from the government. Money? Yes, sir. No worry. In fact, a writ petition is not the proper forum. First me. Deeply applied. Matter is about land acquisition. The trading is complete. So, may it come up from any date as per the convenience of the land acquisition is disclosed. And bench for this is bench for. So, readings are complete. So, what do you want? Admission hearing any date. So, you fix next month. First, no. Second, first. Yes. Okay, I take answer for well. Tomorrow. The IOCL was supposed to have the instruction. Yes. There's an interim order operating, and day before yesterday, we received the mail from the senior manager that the Parawise comments are still. What's the question of Parawise comment? It's only an issue. You just give me a Parawise comment. What has been said? They are there. They just said they are preparing their day before yesterday. The mail we received the mail. Do you know the orders passed by this court? We have only asked for a query on a single point. There's nothing else. There's nothing else to be discussed. Yep, we have expressed the rocket query to the. We'll ask them to appear in person. Yes. There's no point dealing the matter. Who do we ask? Upon what? It's not the way. That is the respondent number. Side. Oh, respondent number. Right. This is the fourth occasion they're getting time. This is the, yes, this is the fourth time it is listed. Right, Mr. K. Chaudhary, learned senior counsel for the petition. You just say this is order dated 18/3/2024, huh? The first paragraph. Okay. Then you write, Mr. P. Bhardwaj, learned counsel for the IOCL, submits that para-wise comment are being prepared and he accordingly needs time. Good stuff. On perusing the various orders passed by this court, it is seen that this court has given time to the counsel for the IOCL to obtain instructions as to whether the petitioner had submitted the temporary registration certificate, like temporary authorization of registration for new trucks, comma, as required under the PQC. However, instead of obtaining instructions on the single issue that has been raised in this case, comma, the respondents have time and again sought adjournment. This court is not amused by the reason for asking for time to obtain para-wise comment when the only issue that has to be considered as on date is whether the petitioner had submitted the temporary registration certificate, like temporary authorization for registration of new trucks bearing registration number AS01 RC1545. Full stop. As such, next para, in view of the reason stated above, comma, this court directs the respondent number 4 to personally appear before this court on Friday, on Friday, on Friday, with proper instruction with regard to the above query made by the Mr. P. Bhardwaj, learned counsel for the IOCL, can inform the respondent number 4 to appear personally before this court at 10:15 on the second. And it up to observe that it's the accepted 5 seconds with personal date. If it is fine. That's what you're asking for para-wise comment. That much. Okay, right. In the event the respondent filed their affidavit on or before, right, on or before Thursday, comma, the personal appearance of the respondent number 4 shall be dispensed. The respondent number 4 shall need not appear before this court. So, however, the affidavit should specifically clarify the issue raised by this court. The other two matters, one is no, but the truck number will be different. Out here, truck number is AS01 RC0745 and AS01 RC0746. Yes. Okay, out here, the two truck numbers. Okay, that's all. And then item 3. Is the shortfall. Out here, it will be the same paragraph 23. No, the order is out here. 20/03/2024, first paragraph. Huh? Then you write, Mr. So has for that for has a short time, so it's the same thing. Huh? Then and you just see, I'll give the correct details. You just see this order 20/03. Just see that. Same date.
Interim order will continue.
Interim order to continue till the next.
Before
This one. This is the non-payment of higher charge matter. And I have approached to the authority also by making
Where is the admission?
technical my lord, lordship will see my lord for random sake my lord, lordship will see page 19 my. Page 19 for a moment.
There is your bill, Mr. Council. There is not an admission.
Bill my lord, they have put and seal and file.
Seal means they have received it. That's all. Doesn't mean they have admitted it.
My lord, basically my lord, whatever original higher letter is with them. My.
Huh?
The moment we submit our bill, my lord, they take all the higher pay.
Where is
And similarly, circumstances, my lord, your lordship has already disposed of my lord.
no, that was because of admission in affidavit.
So at this stage, my lord, may I say one thing, my lord?
only 30th
Notice may be issued at this stage, my lord.
Right. Heard Mr. Jay Barbuya, learned counsel for the petitioner, who submits that the respondents have till date not paid the vehicle hire charges amounting to rupees 44,72,902. He also submits that the various representations made by the petitioner have not evoked any response. Returnable in 4 weeks. Mr. S.S. Roy accepts notice on behalf of all the respondents. This is the matter after 4 weeks to enable the respondents to file their affidavits.
5 and 6, my lord, only figure will be
5 and 6, 5 will be 30,
30,
comma 67, comma 488,
my lord.
and item 6 will be 25, comma 53, comma 314. Except for
Yes, yes.
Oh, okay, pass on for the time being. अभी आइए
30 percent to the order of the court. It is 4th of April 2024. I have filed proper, I mean,
It's IA 1115 115.
yes, no, the 947.
947 is not proper.
But that is not proper, but it is not, I mean, disposed this matter, therefore it is
That is a different thing. The proper one is which one? 1115. IA 1115, I think.
I don't know.
What do you mean you don't know? You're the one who filed it.
No, because number is. But I have not, they have not given the number because earlier I was not disposed of. Therefore, it
No,
remains.
no, number is given. In my copy, it is given. We have not checked. That you want the SE, Superintendent Engineer.
To be inside.
What is his name?
Kulendra Kumar Bhai.
Shailendra Kumar Baisi. Okay. Another thing, you have said that you want this respondent number 5, the SE, to be impeded as a party in view of the division bench order in a writ appeal. But that division bench order is on a PIL. That's a different issue.
Correct.
And the respondent number 5, there is the chief engineer. Out here, it's SE.
No, my submission was that when I filed the PIL before the Honorable Supreme Court, that time I did not impeach anyone, any party. But on the strength of the allegation, an Honorable Justice differs.
Anyway, right. Any objection? No objection, I think. Impediment. No. Where's the council?
Already, as you said, as the secretary, I
No, that's another thing, Mr. Council. There is something called procedure. Let's see, who is it?
opened that.
Tell him come. Can you just tell him to come? Hello, Padre. Let him come. Let the council come. Yes, any objection? No. Correct. Third, Mr. D. Chaudhary, Learned Counsel for the applicant, who submits that the principal secretary to the government of Assam, Department of Social Justice and Empowerment, Dispur, Guwahati, Assam, should be treated as respondent number 12. Miss
A. Loda,
Eloda appearing for
Social Justice, RM. On behalf of
correspondent number
4.
number 4. And Miss S. Bora appearing on behalf of Miss R.B. Bora for the BTC submit that they've got no objection to the prayer made by the applicant's spouse. In view of the above, the principal secretary to the government of Assam, Department of Social Justice and Empowerment, Dispur, Guwahati, Assam, is impeded as point number 12. The application shall submit a corrected copy of the cost type to the registry. I is accordingly allowed and disposed of. Then you write in the main certificate 3151. You write in view of the order dated 22/4/2024, passed in IAC 989 of 2024. The principal secretary to the government of Assam, Department of Social Justice and Empowerment, Dispute, Guwahati, Assam, is impeded as point number 12. Issue notice to the point number 12. Who accepts notice? With Eloda, accept notice on behalf of point number 12. This is the matter after 3 weeks to enable the respondent counsel to file their affidavit. F. Boro appearing on behalf of Harbi. Out here also,
Same, but the respondent number 12 will be Department of Women and Child Development.
out here, it will be everything will be same except
Department of Women and Child Development.
Principal Secretary, the Government of Assam, Department of Women and Child Development. Okay. As a point number 12. Same thing. Out here also, your point number 4.
Yes.
They are same model, main people. Miss Rubin.
I won't be able to accept on behalf of Women and Child Development.
Acha. Who is accepting notice on behalf of Women and Child Development? You call, who is the task? Mr. Roy, can you pray for Women and Child Development? Who? Arunda.
We are for Social Justice.
Earlier, it was
No, for,
Social Welfare Department.
I know,
Now,
social,
Now it's.
Women and Child has been bifurcated.
Yeah.
You can take. Okay, Mr. S. Roy, accept notice on behalf of point number 12. Okay. Then you give extra copies. Then next. In the main case, he'll accept. After everything is safe. Only in the main case, Mr. S. Roy will accept. Perfect. That's it.
Apply to allow.
Good stuff. Okay, registry to reflect the name of Mr. S. Roy in the project.
Please, Your Lordship.
Correct, Mr.
T.S. Dekka, Your Lordship.
T.S. Dekka. Then
Appearing on behalf of
wait,
T theory also.
Yes, data appearing on behalf of Mr. T. Dury, learned counsel for the applicant, says that the Union of India, represented by the Commissioner, Ministry of Jal Shakti, Department of Water Resources, Rural Development, and Ganga Rejuvenation, should be implemented as respondent number 5 in the respective. Ms. Eloda appearing for
All the
all the respondents submit that she has got no objection to the same. Accordingly, the Commissioner, Ministry of Jal Shakti, Department of Water Resources, Rural Development, and Ganga Rejuvenation is implemented as point number 5. The applicant is accordingly directed to submit a corrected cost type to the registry. I is accordingly disposed of, is accordingly allowed and disposed. Then in the main case, you write, in view of the order dated 22/4/2024, passed in IAC 1053 of 2024. The Commissioner, Principal Judge Shakti, is implemented as respondent number 5. Issue notice to the respondent number 5. Mr. Okay, Ms. A. Gaya, CDC accepts notice on behalf of the newly implemented respondent number 5. Applicant shall serve extra copies of the writ petition to Ms. A. Gaya. List the matter after 4 weeks. 4 weeks. And then in 12 and 13 also.
Yes, 11.
12 and 11, 12, 13, same order, huh?
Much applied to also.
apply to
Except the IA numbers will be different. Okay.
Item 7 and 8.
Yes,
Yes, fine. Petition for office.
so we,
Window.
William, please, what is that? You take up IAST 947 of 2024. 1115 of 2024 together. I heard the petitioner in person who submit that Shri Shailendra Kumar Baishya, who is the superintending engineer, Jorhat Circle, irrigation, to be impeded as with point number 5 in WPC 4815/2020.
418.
4185/2020. Mr. N. Upadhyay appearing for
Irrigation department.
the irrigation department submits that he has got no objection to this. So accordingly, Shri Shailendra Kumar Baishya, superintending engineer, Jorhat Circle, irrigation, is impeded as point number 5 in WPC 4185/2020. The petitioner, no, the applicant is accordingly directed submit corrected cost type to the with the register. In respect of WPC number 4185/2020. The applications are accordingly allowed and dismissed. Then you write in 4185. Wait for that.
4661. 6431.
I'm looking at this 485. What is this 485? IA 485. What? IA 485. What is?
418.
Huh?
418.
No, there is 485. of 2015. What is this? Failure to understand the order?
There I 485 no order was not online.
Huh?
I have 485 order has not been online.
No, which I recollect what he said. He is supposed to not to file the reply in my HTTP. And he has filed this IA to give him
Reply it.
to permission to file reply.
He wants to file reply affidavit.
Okay, not file reply.
In which
4185. 4185.
485. So you have filed your counter affidavit. So let him file reply. What is
Already
it?
filed.
Huh?
Already filed.
He has already filed.
Already filed. So this has become instructor.
We can instruct.
Okay, right. In IA 485, huh? Good stuff. The applicant's counsel, the applicant slash lead petitioner submits. No, the applicant slash lead petitioner, who appears in person, submits that the present application has become instructed as the petitioner has already filed his affidavit in reply. In WPC 4185 2020. Accordingly, the IA is dismissed as instructed. Then there is one. What is this 151?
1511 that is I mean
Oh. Suspension of payment to R7. This is different.
only notice was served by this.
Huh?
Only notice was served to the respondent number 7 by this.
I disclose or by you.
The order was passed by this.
Other pass, the affidavit served by you. But why should it be stopped?
Because that is the illegal dispute because 80% cadences was stopped.
Huh?
There was the illegal. It is general should be 30% cadential. To allot the work to a particular bidder, he has raised to 8%. That's it.
So, and this person is working.
Yes.
He's a contractor.
Yes.
80% work has been done by the now it is completion lot.
Like that is different. The completion is different. But there are five is
What is this 2630? I could. Wait, one by one, wait. I'll have to take- Huh?
Implement of the private respondent 7.
The effective one lot. So
No. 2630 was the implement of private respondent 7.
This is disposed of.
it is disposed of already appeared lot.
It's not this. Very nice. Okay, then you write in the main case, huh? In the main case, you write in this 4185, you write. In view of the order dated 22/4/2024, passed in IAC number 947 of 2024 and 1115 of 2020. Shri Shailendra huh, is impeded as a point number 5. Petitioner, no, issue notice to the newly pleaded as point number 5. Read petitioner is directed to take steps for service of notice. Issue notice returnable in 4 weeks. So that's point number 5. Read petitioner is directed to take steps for service of notice upon the respondent number 5 by registered post with AD within 3 days. List the matter after post. That's the thing. Now, with regard to wait, then the what is this? I got 151. This is with regard to what? They should not be paid. Why?
And
Lordship, notice was issued by this court long back to WBC 6431. But they don't file any counter affidavit.
Have they appeared?
they appear lot. Perhaps today it is not there lot, but
Like they are no. Appear, but there was no, I go and report that they appear. I don't know. At least they have to obey the order of this court. Long back notice was issued by this court. They didn't file any counter for months. 6 months, 2 months on both sides of it. Neither by the chapter 7 nor by the number 5.
No, where are they appear? Where is the appearance?
Check with me, IA in.
Huh?
Check with IA at the time of hearing.
They have not appeared.
They appeared, I know.
They appeared.
Let me see the cost file.
They have not appeared.
No,
They have not appeared.
they have nothing to actually trusted. Everything is
One name has been shown, Lordship.
Right. In 151, you're right. Heard the petitioner, I heard the applicant in person. I had heard the writ petitioner in person. So Mr. N. Upadhyay appears for the state response.
One D. Mohanta appears, Lordship. Police people.
ये बात If no one appears for point number 7. So his name appears in the policy. To be issued to suspend the payment for the contract work being done by the private is point number 7. What to do? If he doesn't come, should we suspend payment?
Lordship may not do so, Lordship, today, Lordship. Let it be.
Right, right. Uh, in the interest of justice, one last chance is provided to the respondent number 7 to appear and file their objection to the present application. Note, failing which the matter is liable to be decided on the basis of the materials on record. Note, this is the matter. Then, this is the matter of the police along with the means written.
That is not, I guess. No, I guess. Too many.
There's so many years what to do. He doesn't want a lawyer. He's doing it. Everything is. No, there's no point. We're wasting time now. Yeah, your prayer has been allowed for that impeachment. Not like.
Court 1. So this is a contempt. We are alleging violation of an order dated matter.
The last order of this court.
Yes, madam. That I'll explain, madam. The 20 says, madam, from the date of alleged contempt. From madam, the original order was of 23/3. 22. It had a limit, it contained therein a limit of 6 months. After that, my lords, 6 months and my lords, there's a statement, my lord, I made that they have made the consideration. Now the only payment part remains, consideration plus payment, which was forthwith. Then, my lord, we move the honorable court, my lord, in 23. It's at page 21.
I need.
9/8, my lord. So, my lord, if lordship will see, kindly observe in that order itself, my lord.
But then why did you, then when it was withdrawn on 9/8, then when did you file it? Okay.
Then, my lord, we communicated it on 4/10. 4/10 to the authorities that there is an order. And my lord, this petition was preferred in March. So section 20, my lord, we allege contempt from state of my lords. That's 6 months.
I don't think it's anyway. Right, heard Mr. Deep over.
Let's-
Learned counsel for the petition. Who submits that the order dated 23/3/2022 past it. WPC 1775/2022 has not been complied. If you notice, returnable in 4 weeks. Petitioner will take steps or several of notice upon the respondent by registered society with its PDF. This is the matter of course.
Deep level.
Lordship, we are filing an affidavit also. So 1 week time.
Say Kalita appearing for the Industries and Commerce Department. Submits that he will be filing affidavit within a week. This is a matter after this.
Applies.
Yes, Mr. Roy.
Lordship, it's done for vetting, not yet received back.
I'll just read an order
I've
of
read-
7th August 2023. 7th August says, Mr. S.S. Roy, learned Spencer government advocate, representing all the respondents have submitted that the counter affidavit on behalf of the respondent is being made ready
Lordship.
and will be filed within a week's time. This you said in 7th August. Now, that 1 week's time ended in August. And since then, another 8 months have passed.
Let it be on Friday. Because it was sent for vetting, Lordship, not
Then we call them.
Lordship on Friday, Lordship.
Right, Mr. S.S. Roy. Says that the matter may be discussed on Friday. So that affidavit is filed within that. This court has noticed that in the order dated 7/8/23 passed by this court, Mr. S.S. Roy had stated that the counter affidavit on behalf of all the respondents was being prepared and would be filed within a week's time. So, however, despite more than 8 months having elapsed since 7/8/2023, no affidavit has been filed. In the event, no affidavit is filed on or before 26/4/2024. Consequences may follow.
Next, please. I pray for some time to file our response.
Right?
And another, we would like to have explore the possibility of an affidavit settlement in the party. If that is possible before the appointment of an arbitrator. Because cost of arbitration is also will be involved once an arbitrator is appointed. So I was suggesting to my senior also if we can have a after the election matter, if this matter might come to say matter because my submission will be that there is no the costs have not accrued for them for even initiating an arbitration. dispute.
All those things, you see, the court only has to see whether there is a arbitration clause.
No, your lordship, whether there is an arbitrable dispute, it's also to be seen.
In exceptional case. In exceptional cases.
Because if there's no arbitrable dispute,
But there is an arbitrable dispute.
I'll show your lordship, if I'm satisfied that there is no arbitrable dispute as of date.
But you also, if we can have because the amount involved is not much. So if we can have an amicable settlement prior to, otherwise,
Look, there's no point keeping this case pending here.
just one last opportunity, if we can have it and finish it out. Because once they have invoked, the limitation also starts. Because it's otherwise appointing an arbitrator will entail cost for everyone.
Naturally,
Necessary.
but why you are taking adjournments all the time?
You all also right, just being engaged yesterday. But
You did
I-
engage yesterday. Earlier one annexing was there, an annexing.
yes, sir.
Huh? Annexing out here also in January.
I understand that
And then again, yeah,
this matters has not been, we put up, but
when do you want? Or what do we do?
I'll understand, say that it will maybe granted, my lord.
What do, huh?
They say that it is granted, my lord, they will accept.
Okay, Mrs. G.S. Hayawala appears for the petition. Mr.
These and
C. Senapati appears for
the respondent number one.
the point number one. Have you any Vakalat Nama?
Yes, sir, I think so.
I don't know. You have to know. You have to counsel.
Yeah, I've been informed there.
Okay. While Mr. K. Gogoi appears for the point number. Huh? I know. The petitioner has prayed for appointment of an arbitrator. In terms of the subcontract agreement dated 18/12/2020. As the dispute has arisen between the petitioner and the respondent. Next, Mr. C. Senapati, the general counsel for the respondent number one, submit that an out-of-court settlement is being attempted by the party, and there is a likelihood of a settlement being made within 8 weeks. Yes, within 8 weeks. So, sir, accordingly, this matter after. Not so. Who is the petitioner person? Right. No one appears for the petition. Super. The present case relates to the appointment and resignation of 4 arbitrators. Super. The present arbitration proceeding is being conducted by a 5th arbitrator, whose removal is sought for by the petitioner under section 15 of the Arbitration Act 1993, and appointment of a new arbitrator, appointment of a new independent arbitrator under section 11(6) of the Arbitration Act 1990. Super. However, no one appears for the petition.
My lord.
Here for the petitioner?
No, yes,
He's not here. Not your case. What to do? Mr.
Take it up.
AK Data appears for the respondent. It's a section 15 application.
Yes, 16.
15. You are saying that there is an alternative remedy under under section 14. But he's saying that it is not only an application under 11.6, but it is also an application under section 15.
Yes.
That is case. Right, anyway, right. As no one appears for the petitioner, in the interest of justice, the matter is adjourned for 3 weeks. How do you, now that officer, the fifth arbitrator,
We committed to lapse. There is some lapse on our part. We have to decide this matter within the time specified 12 months.
Mr. Counsel, one thing. The fifth arbitrator, I think, is your own person.
Now,
Then will he come under, will he be hit by 12.5 in the 7th schedule? Because you cannot appoint your own arbitrator. You're an interested party.
as per the mandate of the agreement, my lord,
Mandate of the agreement does not hold any water any longer.
we fail.
Huh?
We fail it to decide the case within the time specific time. And now his option is
Only problem is he's not here.
to select a
Right, just right. One of the issues that has to be decided is whether the arbitrator who has been appointed by one of the parties can continue as an arbitrator. Besides, the arbitration proceedings not being completed within the time specified in the arbitration clause of the contract agreement. That's portion, no? As no one appears for the petition.
24. In terms of the last order, my lord, we are taking decision on the letter, my lord, communication for some time, my lord. And additional work completed by us.
You have been taking time over and over again.
No, my lord, the authorities there, they have informed me that they will be deciding on that.
When? Deciding when? Deciding that they will have to decide, but when?
2 weeks time, they are considering it, they have called me. Right out.
The stage Gupta Larat CGC submits that. The respondents will take a decision on the additional work carried out by the petition. Accordingly, listed right after 2 weeks.
I don't know, 14th of May. 14th of May.
14th of May.
Keep you. This is a matter regarding non-payment of
It lapsed, the money lapsed.
money left.
Then
My lord, a communication dated 16th October 23. I think that is there in the file. After I have
16 October 23.
23, my lord, a communication, my lord, from the director, my lord. I think here also, I have to copy.
No, I've got it. No, I've got it.
So, my lord, we are not disputing the thing.
Then
So, my lord, the last line, however, steps are being initiated for payment of the pending amount during the recent financial year.
so that current financial year has gone.
No, my lord. What they meant is, my lord, 24, 25. This,
How can it be?
my lord. Steps have been taken, my lord. So we propose the money was allotted most probably in the current financial year.
So we'll give a direction. How much time we want? Yes, otherwise we are going to only adjourn. You're going to only make excuses.
No, my lord.
pilot will fix the matter in Friday. I will come with a concrete instruction as to what steps have been taken and when they are paid. So my lord, sir, dispose of the matter on Friday.
Okay, right. Mr. Ardhar, Learned Counsel for the respondent submits them. In terms of the communication dated 15/10/2020, issued by the Director Tribal Affairs, bracket P, SM. There is no dispute with regard to the amount payable to the petitioner. That is 12, 58, 333. However, he will come up with a definite instruction on Friday as to when the amount can be paid by the respondent. This is a matter of fact.
But 10 means 28, my lord. So I may not, my lord,
Today is a holiday.
Monday. My lord, I may be out of session on,
Of the 29th, put 29.
Wait, the lot. This is regarding an order of suspension of a TDS license. The order is at page 33.
PDS,
Yes, Lord. Public
TDS.
distribution of service.
With the instruction that the proposed notice was issued on 3/5/2023, but yet not yet replied.
notice. So what have you done? Is it still under suspension or?
And the law is very clear. The law says beyond 90 days it cannot be there. And this is more than a year now. And there are
The
judges also.
proposed notice was done on 3/5/2020. Yet not yet replied.
Then, but you have not, why are you suspending only? Then you terminate his license.
The suspension cannot.
So his case is that suspension cannot be beyond the 90. And it is then the suspension have to go. What remains?
If I may just produce the rules, Lord.
The proposed notice has been issued. If no
So what? So show cause notice has been issued.
issue within
So let us see the rules. What does it say? Does it say that once show cause notice is issued, the suspension can continue?
No.
Let us see the rules. What does it say?
Page 30, internal page 13. There is the Assam Public Distribution of Articles Order 1982. Internal page 13. Rule 15, sub-rule 1.
Yes.
If any license or his agent or servant or any other person acting on his behalf contravenes any of the terms of the conditions of the license, then without prejudice to any other action that may be taken under the Essential Commodities Act, his license may be cancelled or suspended by any order in writing by the licensing authority, and an entry will be made in his license relating to such suspension or cancellation. No order of cancellation shall be made under this clause unless the licensee has been given a reasonable opportunity or stating his case against the proposed cancellation but during the pendency or in contemplation of the proceedings of cancellation of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case.
Yes, David. The license can be suspended for a period not exceeding 90 days without giving an opportunity. So now it has been given to you. Yes.
I have no instruction whether this has been actually served upon the client or not, or the petitioner or not. And one more thing, he is saying that this particular so called was issued in the month of March 2023. Now we are in April 2024. What has stopped them from taking action ex parte? They have not done that. That therefore shows their intent not to proceed. And if you also see the impugn order, the impugn order was of an order where it never contemplated any proceeding. It was in the form of a punishment itself. They say the license is suspended, contemplating or pending any disciplinary action, nothing of that sort. This was an order whereby
Have they filed an affidavit?
they have filed an affidavit. Therein, they have not stated anything regarding these aspects
so-
of the petitioner.
So you bring the report, we'll dispose it of.
Anything.
When can you bring? A small issue, nothing. Only thing you see, one thing is very clear. When did you give a copy of the, but you also have to take care at the side.
I will
Have
take
you
my
received?
steps, because this is the first time it is coming from his side, that they have issued the so called. The last occasion, we were not able to say anything on this line.
Okay, good.
And the instruction from the client is, till date, they have not received any sort of so called. And in the affidavit which the government has filed, therein also, they have not referred about filing of any, submission of any so called notice.
So let us bring the report. Good. Okay, right. Mr. A. Sharma, learned counsel for the petitioner. Submits that. The petitioner's license, the PDS license was suspended by order dated 13/2/2022. That means more than 2 years,
23 Lord. 13 to 23,
13/2/2020.
one, more than one.
And that no show cause notice has been issued to the petitioner till this. He does submit that in terms of the Assam Public Distribution of Articles Order 1980, the petitioner's PDS license cannot be suspended beyond life. But on the other hand, Mr. S. S. Roy, then counsel for the respondent, submits that show cause notice dated 3/5/2020, 3/5/2023 has been served upon the petitioner, which has not been replied to till date. Next, on a query made to Mr. S. S. Roy as to whether the petitioner's license has been terminated, he submits that he does not have any instruction. On considering the above, on considering the fact that proceedings are complete, this is the matter when 13th of 13th of this is the matter of 15 minutes, on which date Mr. S. S. Roy shall produce the report, official report.
So one thing is relevant. They have filed their affidavit on 17th of May. 17th of May, the official affidavit has been filed. Now he says the so called was dated 3rd of May. So that means after 15 days they have filed this affidavit, but in the affidavit there is no mention of the so called. So how come this document has now come up?
Anyway,
I will have
we'll
some
see.
reservations. on
Let
that.
you see, we'll see only that aspect. You see, once the suspension is set aside, then your job is done.
Yes.
Only for that aspect.
Obliged.
Till 27.
Yes, Mr. Roy.
I have paid for some time, lot not repeat the answer.
Mr. S. S. Roy is granted how much time?
4 weeks, sir.
4 weeks time to file affidavit with regard to the claim by the petitioner for vehicular hiring for vehicle hire charges amounting to rupees 42,32,251. This is the matter after 4 weeks. Where is your reply? Filing, not filing.
Yeah, because first is this method the petitioner taken back the brief from us.
Huh?
The petitioner taken back the brief from us. We are no longer the applicant.
So
probably
out here
the
name
new
is,
council, probably
what is your name?
my name is JP Moore.
JP Moore, S. Chetia, both of you same.
Yes.
So,
Probably they engage new council.
Okay, I am appearing for respondent number 2, 3, 4, and 5. There is a issue about the tender process is state. 1711. So we have filed in our affidavit.
petitioner given is that the petitioner is a company and he stated in his petition that he has no relation with one Vanguard Security.
We'll give them one chance to appear. If they don't, then we'll list. Mr. JP Moore appearing for the petitioner submits that Mr. S. Chetia and himself will not be appearing for the petitioner any longer in view of the fact that the petitioner has taken back the brief from them. On the other hand, Mr.
D. Chutia.
D. Chutia appearing for the respondents number 2, 3, 4, and 5 submits that there is a stay order due to which the tender process has not been finalized. Mr. J.P. Moore shall inform the registry of this court by way of an application, by way of a letter, that they will not be appearing for the petitioner any longer in view of the reinstated order. He shall also inform the petitioner have you informed the petitioner already before that you will not be appearing for them? Huh?
Yes.
Okay, so then in at the beginning, no, he also submits that they have informed the petitioner that they will not be appearing for him any longer as the brief has been taken from their position. At the bottom right, as no one appears on behalf of the petitioner, as no new counsel appears on behalf of the petitioner. One chance is given to the petitioner to engage a counsel and to engage a counsel who shall appear before the court on the next day. This is the matter after a week. This is the matter after a week to enable the petitioner to engage a counsel to appear on his behalf. Huh? It may be. Then 2 weeks. After 2 weeks, leave a date up. Schedule the case up.
If they put 2 weeks time, file it, for replacing the new.
On the prayer, the petitioner's counsel lists the matter after 2 weeks. No one appears for the parties. List the matter after 2 weeks. Yeah, file the affidavit. Huh?
Wait, take a look.
Just a minute.
In this case, is it already instituted the written instruction? In this, there is.
What was the order passed by this court?
It's located at page 13, annexure 1. The fair price license.
A fresh show cause notice was issued to you,
And hearing is.
then you gave your reply.
I know reply and hearing is. completed, sir.
Huh?
Hearing is already completed, but.
So they have not passed an order.
Yes, sir.
You're appealing for whom?
Respondent number 1, I am for respondent number.
Who has to make the order?
The instruction of my hearing is already there, and the order that passed by the Honorable Court was applied to his tenure. But subsequently, he got he reverted back, but reverted back to his parent part. So I had explained it. Now, they are proposing to include the incumbent who has taken my place.
No, no, you see, madam, you are appearing for whom?
I therefore the contempt of our earlier,
Who is the contender number one?
but that's not about who the assistant director, but it's
Assistant director. So the assistant director was to issue the order, reasoned order. Now, where is the reasoned order? You said that he has complied with it. Where is the?
Yes.
Madam, just it's a simple question. Did he pass any order?
I. Yes,
Your client.
for friends, so not also that I took the part
Oh, you should,
for taking accepted, but there are the one which I thought reverted.
Okay, so you did not pass any order that
I thought
only show cause notice.
I
So who is the new assistant director?
Now, so number 2, yes, please.
That is point number 2. Then why you not passing an order?
That's the part time I have it here. That's my department.
Yes.
Election is going on, Lord. Yes, right.
Lordship, as per my inspection, and we file in our IA Lordship that record number 2, excuse focus notice and hearing is already completed. Okay, it's the start.
Whatever, so you have to take a decision.
No, Lordship.
Mr.
Keyboard letter.
P. Bordoloi, appearing on behalf of the respondent number 2, bracket, the present assistant director, submits that he will obtain instructions as to whether a reasoned order has been passed in terms of the order dated 31/8/2022, passed in WPC 1957/2017. Super. Next para. Miss Miss R and the, R
Data.
Dekha, Miss R Dekha. The learned counsel for the petitioner submits that the fresh so-called notice issued to the petitioner has been replied with, and hearing has also been conducted.
On
So,
28th.
thus, the only requirement is for the new assistant director to pass a reasoned order. To pass a reasoned order. This is the matter when. This is the matter on. Estimate to enable Mr.
Keyboard letter.
P. Borloi to obtain instructions.
Apply.
my friend,
Miss
he told
P. Chaudhary appears for the respondent number 1. The early assistant director who has now retired.
that he did it.
No one appears for the petition on call. Yes, madam, are you there, Miss Bora? Are we? Huh? 35. List the matter after 2 weeks.
Here we have filed our executive lordship
2 weeks time to
Go to civil court. There's nothing. Go to civil court.
and lordship.
They are saying that it's state orders.
Record.
I will reply it on that.
Mr. Counsel, this is a contempt case. This is not a case where you say, this is correct and then this is not a normal case.
They are saying that work quota is fake. But here the administrative approval, technical section, that they are not saying that are the fact. Only there is a fact in the work quota. But I will.
The problem is, you see, Mr. Counsel, the problem is this is a contempt case. Now you come to the order. Let us see the order together. Page 70.
Page 70. First pyramid. That's it.
Come to the para 5.
In their view of the methods, this repetition is disposed of by directing the petitioner to approach the committee constitute by the notification dated 15/11/2021 by placing all the reference and the claim and the claim. It is needless to state that on receipt of the document and claim, which may be submitted within 10 days from today, the committee will look into the correctness of the state claim and make recommendation for payment. A huge amount of public money is involved. The committee is directed to take all the possible steps. Committee will complete the aforesaid exercise within a period of 3 months from the date of receipt of the document and the certificate of the
So, Mr. Council, you see, the thing is that the writ court did not say you are correct or they are correct or they are. It only asked the committee to look into it. Now, a writ court is not a court where you can lead evidence. Or, you see, it's only, a writ court is only a court where the factual dispute, there should not be any factual dispute, and the dispute is only with regard to the law to be applied. Now, out here, there's a factual dispute, and writ courts cannot take evidence. You have to go to the civil.
The similar matters are pending before this honorable court.
Maybe, but I am not similar. Sorry. Huh?
Separate, every case is separate.
I know, right?
But only allow me 2 weeks time. I will file affidavit in the day after I will decide on that. When it fix the matter, my lord, next week, my lord, I file
What did you find
affidavit in the flight. I have filed the affidavit.
to counter this,
Yes, my
so that you can file it in in the civil court?
no, my lord.
At the end of the day, you have to go to civil court, whether you file affidavit in reply or not.
Yeah, so what if I maybe my lord decide that will allow me to file affidavit.
You will list it on Friday, you get everything ready by Friday. You file it by Friday,
Monday.
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 Correct. The affidavit filed by the state respondent at para 4 of the at para 4 is to the effect that the sanction orders of the said scheme that have been issued by the government of India were later found to be fake and did not exist at all. As such, FIR was filed and that the CM Special Vigilance Cell, Assam, is also investigating the matter. As the sanction orders were fake, BTC cannot shoulder the illegal liability that has accrued in favor of the petitioner. The above clearly goes to show that there are disputed questions of fact which cannot be decided in a contempt case. And prima facie, the petitioner would have to he would have to approach the appropriate forum. However, as the petitioner asked for time to file affidavit in reply till Monday, list the matter on Monday, that means 29. On that day, I'm closing this, so you make your reply properly,
My lord, yes,
so that you can use it in the civil court. That's all.
all right. Okay.
The order which is not complied with that is 40 Lord. We are just taking time notice later, they have filed their affidavit, not to comply the order.
Yes.
My lord, PTC council will step in to the
Who?
This is something Mr. B. Chaudhary.
Let's wait for it. Let him come. We'll wait for it. Yes, what is your case?
My lord, it is simple, my lord, your lordship, when passing the order, the party tax has to be, my lord, has been avoided, my lord. In regard to the page number, my lord, 55, pair number 26, my lord.
Page?
Page number 55, my lord, pair number 20, last two lines, my lord.
Yes.
Yeah, last time I'm reading, my lord. It is also noticed the spring order that aimed for 2023 has not been put to Senate. Whereas, my lord, in 2146, I have challenged this spring order, my lord.
Let me see this 2146. Arithmetic. 2146.
Page number 15, my lord. Pair number 17.
Okay, 10/4/23 has been put to challenge. Okay, then
And, my lord, in regard to the close, I'm just requesting you to come to page number 114, my lord, of this petition. Pair number 41. Wherein, my lord, the performance, formation of the contract has been finalized and can be concluded. Subject to submission of the performance agreement.
this is some other case.
The relevant person was Diaul Pasa case, my lord.
Huh?
Diaul Pasa case, since the relevant judgment has been in 2674, my lord. When I'm annexed this,
You go to the division bench, Mr. Khan.
then, my lord, at this liberty can be given to approach the civil court, my lord, at this. Civil court, my lord.
Huh?
Liberty is always there, but the
Liberty is always there.
But you have, there is no mention in the judgment, my lord, for regarding the approach in the civil court. That can be granted, my lord.
I don't know liberty how.
that case you also have minor withdrawn the equity.
You should have asked for it that time in that time. Earlier. Now when we have passed the order, it's very difficult.
At this, my lord, liberty can be, otherwise, my lord, I've done the mistake, my lord, without the expense of the formal order, I did the work, my lord. This is my fault. As if, so there is a student matter of fact. So, since my lord, liberty can be given to approach the civil court, my lord. This is only my humble request, my lord. This is my,
Why don't you go to the division bench and ask them?
where my lordship will, it will give how the division bench will ascertain, my lord. This is why I will suppose the civil court, my lord. That liberty can be only given, my lord.
Now at this stage so difficult. After passing this order, you should have asked for that time only earlier. And that
I never thought this petition maybe will dismiss my lord.
Will be dismissed. You never thought it will be dismissed. You thought you'll win.
Because where the measurement has been done, the execution authority has find out the materials and all. I never thought my lord. This is the only humble request, my lord.
The problem is that at this stage is not possible. We cannot change. You see, review of an order can only be made when there is some apparent.
I met a request for the approach for the civil court matter.
Ah,
I have met a request in the review petition for regarding liberty can be given to approach the civil court matter. At least that can be granted, my lord.
I don't know what you say.
But
That part I have nothing to say. On merit, already on merit I have disposed of. But without making any observation on the point of limitation and all, that's recorded from my part. But can, in a review, can that be done? Review melody, separate melody, there is no error melody. Only one error is that we have said that speaking order has not been put to challenge, but it has been put to challenge. That's it. No, it's there, page 49 document. Page 40. 46. Page 46, para 3, page 40. Okay. Yeah, document taken from the, in fact, they made the submission of it. Yes. Yeah, I've put it here, para 1. Para 3 is there. The para 3 is there.
But in case it was
There's a small error, that's all. But how does it prejudice you?
it is my humble request, my lord, to just liberty can be given to approach the appropriate civil court matter. Because of some similar case is also there, my lord. Therefore, I will put that on. I will withdraw the ethical liberty approach.
How will we allow when we have dismissed your case?
You dismiss, my lord, but only liberty I'm asking, my lord. Only liberty. Because it is a disputed matter of fact, my lord.
Where is it disputed?
Regarding
It is not disputed that you were not given a formal work order.
But earlier in so many of places, my lord, the formal work order, they have taken the measurement.
That is why we have got to put a stop to this kind of contract work. This is not legal. It's invalid.
Again, my lord, but for that time, where the judgment would first, but I particularly am damaged, my lord. This is the only I'm asking for.
No, but out here we have given some observation, I think. Wait
Yes,
a minute.
my lord. It's a department at your discretion. You can consider claim of the petition, the prayer number 26, my lord.
I said that the respondents, however, can consider the claim.
What to say?
Okay?
If read court, they are not.
No, Mr. Counsel, I'm sorry. You cannot come to a writ court with a begging bowl. You've got to demand your rights. You had demanded your rights, and this court found that it was not tenable and accordingly dismissed it. Now, if you agree with it, you go to the division bench. You can ask the division bench to do it. For this court to change its mind is difficult. It's not in tune with the provisions of the law. If I allow you to do, if I change the order, then I'll have to change the entire paragraph. And how can that be done? You look at this, you just look at para 26, whatever I said is para 26. I have said the petitioner cannot claim that any enforceable right of his has been violated. The work allegedly done by him was at his own risk. The minutes of the joint verification process does not give any right to the petition. And then it will go against the it will go against para 27 also. I'm sorry. Okay. All my sympathies are with you, but then you should have asked this at the beginning when you were arguing with me. Like, heard the review petition and person. Also heard Mr. Bigoy appearing for the state respondent, stay as for the PWD and Miss for respondent number 3. The impugned judgment and order dated 17 to 2024 passed in WPC 4982/2020 and 2146/2020 has been sought to be reviewed by way of this review petition on the ground that certain facts were overlooked by the expert. The petitioner in person, the review petitioner in person submits that in para 55, no, in para 26 of the impugned judgment and order of this court have stated that the speaking order dated 10/4/2023 issued by the chief engineer PWD Border Road had not been put to challenge. Though prayer number Roman 3 in WPC 214 had prayed for setting aside the speaking order dated 10/4/2023. He also submits that similar matters are pending before the the civil court, and for which liberty may be given to the petitioner to approach the civil court. Mr. B. Gogoi, learned counsel, appearing for the PWD submits that the that the observation made in para 26 of the impugned judgment and order that the speaking order dated 10/4/2023 has not been put to challenge appears to be a typographical error, inasmuch as para C of the impugned judgment and order has clearly stated that the speaking order dated 10/4/2023 has been put to challenge in WPC 2146/2023. He also submits that no grounds have been made out for review of the impugned judgment and order, and as such the same should be dismissed. And as such the review petition should be dismissed. I have heard the name of for the party. As can be seen from the impugned judgment and order, para 3 of the impugned judgment and order states that the petitioner has put to challenge the speaking order dated 10/4/2020 in WPC 2146 of 2020. So thus, the observation made in para 26 of the impugned judgment and order to the effect that the speaking order dated 10/4/2023 has not been put to challenge appears to be a mistake. So, however, the same does not take away the fact that this court has not found any impossible right for the petitioner having the filing and due to which the state petitions were dismissed. So further, the petitioner has not been able to show that any prejudice has been caused to him due to the wrong observation made in paragraph 26 of the improving judgment and order, comma, as now vis-a-vis para 3 of the said judgment. This court does not find any error apparent on the face of the report or any reason for reviewing the improving judgment and order. Consequently, this court does not find any ground to interfere with the improving judgment and order. The review petitions accordingly.
There is a charge, sir. And any confusion, but we got my interest of my house regarding approval the civil court. There is nothing pending in the civil court matter. There is similar matter is pending high court matter.
The similar matters pending that. Somewhere else, I don't know.
And your judgment.
You go try your luck, the division bench, maybe that's the only way. 336. Yes,
Real lordship, the PTC authority, since there were lots of non-payment of contractual bill and which were exceeded the budget allotted to the township by the state government. They made an audit and lordship, they have prepared the list income which considerably case. Here lordship, the petitioner name is not reflected. And on finding that the petitioner's name is not reflected, and similarly in other departments also, some of the names who have completed the work but name not reflected, they were again sent for the second phase of audit by the private agencies who did the earlier audit. Here lordship, the petitioner name has been forwarded and the report is available.
it is a contempt proceeding lordship. What is the order lordship? Order what? They are trying to go for a new landlordship to file one another. Let us see what is the list. Let us pay operative project for page 48. 48, sorry, page 46. Paragraph there.
This
I think-
order was for comfort to.
I think this case, I think I think this is a big case for contempt. One
Lordship.
person has to go to jail, I think, once.
No, lordship may carry it because the fund that is allotted by the state government to the township was about 800 something crores. And the
I'm not.
work
Mr. Counsel.
amount exceeded twice that amount. So they have to go the work because some procedures were not followed while allotting the work. Accordingly, those who have been found genuine, they have prepared the list of all the departments in terms with the
Mr. Counsel, do you know that this contempt is with regard to order dated 1/888 of 2023?
Yes.
And the order passed in WPC 1/888 of 2023 is based on an order of 12/9/2022 passed in 4337 of 2020.
Yes,
See,
sir.
two orders have been passed. Now the 2020 order has attained finality. And in that case, it has been said that the petitioner is to be paid rupees 2760 lakhs, 60,000 within a period of 2 months with effect from this. That order has attained finality. Now, not complying with that order, now another writ petition was filed, and that writ petition is 1888. Now, 1888 has also not been complied with, and this contempt has been filed. And now you all are trying to go behind the back of these orders and now say that his name is not. When this court has already given you direction that he has to be paid. And out here, Mr. P. Nayak, learned counsel for all the responsibility submit that the only question remaining is with regard to the time period for paying the admitted amount of the petition. Now you all are taking this. If you can say how much you want, but I think this is a fit case to initiate contempt. I think one person has to go, otherwise they're never done.
Allow me a short time.
Just give me the order of.
Lordship may allow me a short time, Lordship. I'll
Nothing will
try
happen.
to,
Nothing will
try
happen.
to, submit the concrete, something.
Nothing will happen, Mr.
Lordship, I'll try to, Lordship, give me a short, as a last chance, Lordship, a short time. Because I have seen the order, Lordship, it was based on two orders of this, court.
None of them have been put to
Lordship,
challenge.
I'm trying to convince, Lordship, Lordship may.
You
give
don't
me a
have
short
to,
time.
we will take care.
Lordship may give me a short time as a last chance. Thereafter, Lordship, if nothing happens, Lordship may take it.
Last order is already recorded, Lordship. They have not seen any. The last order of the Lordship recorded. Okay, just give me this order dated 12/9/2022. Passed in WPC 4337 of 2020. Just print it. 4337 of 2020. Who is the respondent? Then all of them should be. Who is it? Akash IAS. Dheeraj Kaur. Okay, right. Third, Mr. P. Sharma. Learned counsel for the petition. And Mr. B. Chowdhury, learned counsel for the respondent numbers 1, 2, and 3. The counsel appearing for the counsel, the Mr. B. Chowdhury had been directed to obtain definite instruction by an order dated 1/4/2024. As to when the list of persons under the PNRD department BTC who were to be paid their contractual bills would be completed. So, sir. Next, sir. Today, Mr. B. Chowdhury has submitted a letter issued by the respondent number 2. Bearing number BTC/RD-8/2022-23/98 dated 9/4/2024. Which is addressed to the senior standing counsel for the BTC. Giving the consolidated list of contractors who are to be paid their contractual due. Mr. B. Chowdhury submits that in the said list annexed along with the letter dated 9/4/2020, the petitioner's name does not appear. And as such, what is going to be done?
Lordship, all the department, it was found that some of the earlier work, those who were not forwarded to the agency to complete the audit, they have been again forwarded, and that forward list of petitioner case is also there. Lordship.
What, where?
Lordship, it was forwarded on 24th May 2000.
And this is of 24th. His name is not here, his name is there.
No, Lordship, that was with regard to the earlier page. This is the second page with the private agent, Lordship, forwarding. And they have again been given reminder later to submit the report on 15 December 2023. The petitioner
Well,
is serial number 21, Lordship, in the name.
He submits. He however submits them. As per letter number BTC bracket no, slash RD bracket NITCON bracket close dash 12 slash 2023 slash 2 dated 24/5/2020 issued by the respondent number 2 to the Secretary of Finance BTC and the annexure and the list that has been annexed with the said letter, shows that the petitioner shows that there are pending liabilities against the petitioner, who is at serial number 21
Yes.
of the said list. Next up. So what is to be done now? Why is he not being paid?
Lordship,
Just a minute.
Lordship, a policy decision has been taken that
His name is here.
Lordship,
His name
this
is not
for
here.
auditing.
Whatever, it's not auditing, it is for compliance you want. We are not bothered about auditing. You want to you audit for all your life. We will now ensure that there's something happens to done. Next. The submissions made by the
Lordship, allow me a short time, Lordship, I will get up a week or 10 days time, Lordship. Lordship, I'll try to get up by which time, since it can admitted amount from the two orders of the of this honorable report, Lordship. It appears. Lordship, by what time they can give? Short time.
that was earlier done also in 2020.
Lordship, only after
Nothing
that,
has happened.
after that only the following documents was
You
forwarded.
see, okay, I'll give you 1 week's time, next Monday.
Yes.
But you please come up with a definite check.
Okay,
Don't come with
Lordship.
a definite check, then I'm on that day, or today itself, I'll frame charges again.
Lordship, but what time they will give it, that Lordship, check, Lordship, I can't say.
Yeah, well, you can't say, but then the
Lordship,
way,
with the definite time when they can make the payment, Lordship, that I will try to get. Otherwise, Lordship, may first think of.
whatever I said, by the answer for the respondent number 1, 2, and 3, and the documents which have been produced to the read with the orders passed by this court clearly goes to show that the respondents are intentionally circumventing the orders of this court. And thereby lowering the majesty lowering the majesty of the rule of law. Next para. A perusal of the order dated 10/4/2023 passed in WPC 1/888 of 2020 shows that the petitioner had earlier approached this court by WPC 4337/2020. Paying for payment of unpaid contractual dues amounting to rupees 27,12,850. WPC 4337/2020 has been disposed of by order dated 18/11/20 by directing the Director of PNRD BTC to conduct an inquiry and to pass a reasoned order with regard to the claim made by the petitioner. Give me that WPC. This have we got the 1/888? No, this. That 1/888. The Director PNRD BTC, Kograjan, thereafter 1/888 1/888 of 1/888 of 2023. Whatever I said, passed an order dated 18/11/22 in compliance with the order dated 12/9/2022 passed in WPC 4337/2020. Stating that the petitioner was to be paid rupees 27,60,00. No, I don't want the order. I want the file. Let's call for the file. Okay, no problem. Good, good. Within a period of 2 months, with effect from 12/9/22. No, no. Don't say that. Don't say within a period of. That's already there in the earlier order. However, as no payment had been made, WPC number 1/888/2026 was filed. In the order dated 10/4/2023, disposing of WPC 1/888/2026, the learned counsel for the BTC had submitted had admitted to the fact that the only question that was to be decided was the time period for paying the admitted amount to the petition. As this court thus directed the respondent to pay rupees 27,60,000. In terms of the order dated within a period of 2 weeks from the date of receipt of the order dated for 10/4/2023 past WPC 1888 of it. However, as stated earlier, the respondents are purposely delaying complying with the order of the though this court is of the prima facie view that there appears to be a case of contempt being made out of Mr. B. Chowdhury, learned counsel for the BTC, submits that he may be given a week's time to obtain definite instructions as to when the admitted amount can be paid to the petitioner. As a last chance, as a final chance, Mr. B. Chowdhury is given time till 29th to obtain instructions in the matter. This is the matter on 29th. So stop. Thanks, Sarah. The letter number BTC/RT-8/2022-26/98 dated 9/4/2024 and the letter number BTC/RT bracket NITCON close -12 -2023 dash dash 2 dated 24/5/2023 issued by the Secretary BTC are made a part of the record and marked as an X and Y respectively. Please tell your clients to take it seriously. Yes. It will be uploaded. You take it, you download it. After you, I'll see in the paper. At the time of I'll make correction to the order.
Highly evaluated.
Maybe not in the case of service, upon that not delivery provided by as per office note dated page 3 and no evidence also filed by the respondent.
Huh?
And there also you have direct to file affidavit matter. It has no evidence.
Who is to file affidavit?
I received my instruction letter, taking my note, but in this week, step it will file my.
Mr. S. Bora, learned counsel for the BTC, submits that affidavit will be filed within this week. Yes.
Lordship, I make it for number 11, Lordship. यहाँ पे I have 659 बता
Okay, Ms. S. Bhattacharjee, M. Bhattacharjee, appearing for the point number 11, submits that she will be filing her affidavit within
I think it's because I could not go through.
2 weeks. Within 2 weeks. Then anybody else filing? Mr. J. Ahmed, appearing for point number 10, submits that he will file his affidavit within. You file?
I'm not filing my
Oh, that means that he will file his affidavit after Mr. S. Bora, after the BTC filed their affidavit.
I'm not sure whether I did elected. I go to the six lot. But it-
Anyway, I've given you time.
What will then my week time? What will picture on 8th of May, my lord, in the Mr.
This is a matter on 8/5.
And
9.
right,
Okay, 9.
Right.
Any interim order?
yes, right.
Interim order to continue. Or have I said anything?
There is
Uh,
no order.
To, interim order to continue till the next.
Same.
Same.
The other case also I have find out.
Same. Party's position is same.
Same.
Public. Okay. Yes, Mr. Roy, I think, correction, I think it's, but he's not here. Hello, correct. How many matters left? Only this. Very fast. What to do?
Otherwise, okay.
No one appears for the applicant. Accordingly, this is matter after a week.